I will now call 124610, State of Kansas versus Riley Moore. Council, please come forward.
May it please the court, Assistant District Attorney Matt Maloney for the state. Your Honors, I'll start right in by addressing the two questions that this court asked the parties to be prepared to address via an order filed 3 weeks ago. Specifically, that is whether unpreserved, non-clearly erroneous instructional issues can be included in cumulative error analysis under 3414 subsection 3, and secondly, whether this court can consider the issue since it was not raised in either party's petitions. Starting with the second question, our position is that yes, this court can consider it for a number of reasons. First of all, I think that as this court knows, a district court's decision is to be affirmed if it is right for any reason. And so even to the extent that the parties did not advance this particular rationale in addressing the cumulative error issue in their briefing, the cumulative error issue in general was before the court. And so even if this court has a different reason for affirming the district court, our position is that it is something that is appropriate to consider. Secondly, we would argue that this issue is, if not technically jurisdictional, it is somewhat quasi-jurisdictional in nature because the appellate court's jurisdiction is set by statute. And 2234-14-3 says that there's only one scenario where a party can, on appeal, essentially succeed on an instructional claim that was not raised below. And that is if the instruction was clearly erroneous. It does not present any other alternatives. It doesn't say that it could also be considered if, as part of a cumulative error analysis, it would entitle a party to relief.
Let me push back a little bit on that. The standard of review for cumulative error is different. It's whether or not the defendant received a fair trial. So if we consider something that happened that was not clear error, but the court has considered it and it's not right either, why can't it be considered when deciding whether or not, as one factor, one thing to look at when deciding whether or not the defendant received a fair trial?
I think, again, I would fall back on the statutory language, which sets this court's and the Court of Appeals jurisdiction. And when you do have a statute that essentially says this particular issue, a non-preserved jury instruction issue, can only be considered for this one particular reason, then going beyond that, I think, is essentially going beyond the statutory authority that the appellate courts have.
But isn't the requirement for a fair trial constitutional? And doesn't that override any statutory mandate?
Well, and I think that's where it's tricky because I think the problem with considering an issue like this as part of cumulative error, as Your Honor pointed out, it then changes the standard of review to give the defendant a more favorable standard. Clearly erroneous requires the defendant to carry the burden of firmly convincing this court that the jury would have reached a different verdict, but for the instructional errors. It's not something where they can prevail by saying that it could have resulted in a different outcome or that there's a reasonable possibility or a reasonable probability. It doesn't even take into account the more general question of whether the trial, looking at it as a whole under a totality of the circumstances, was fair, or whether he was denied his right to a fair trial. So I think there's all sorts of issues that there should be, yes, I understand that in general, there's a constitutional aspect to it. But in this case, the arguments that he raised with respect to the instruction were not constitutional in nature. It was just that they failed to essentially mirror the statutory language and that they failed to define a term that was included within the statute. So in this case in particular, I don't think that the constitutional issue should be overly concerning.
Let me move you to bodily harm question, because I'm really bothered by trying to figure out what the state of our law is. So PIC comments, the pattern instruction comments, say that the district court is not supposed to define bodily harm if it's not disputed that there are injuries. Now, I would say, based on the evidence, that you have injuries in this case because you've got the abrasions and the scraping. Okay. The defense says, well, those are trivial and connected to the act of kidnapping. And for the audience, the facts involved in this case are that a young woman was pulled into a garage and held for a time being, and counsel can perfect that factual statement. But the point being the same. What are we supposed to do in instructing a jury when the instructions say if it's clear that there's not any injury, we don't define it, but yet we have this law that says trivial injuries are to be excluded? That would seem to be a jury question, I guess, when it gets right down to it. So and you don't have that. I mean, it didn't happen here, which is the defense point. So what do you think we ought to do with this?
It is tricky, and preparing for the argument, in a way, it became even more confusing because reading the panel's opinion, they talk about the fact that the bodily harm doesn't actually require physical injuries. And yet, like you pointed out, there is this case law that says, but trivial injuries that are inherent in any forcible kidnapping are not to be included. And that if that's all you've got, then that would apparently be the situation where the instruction is appropriate. I think that it's a fine line. I agree with the first point that you made, that in this case, there doesn't seem to be any dispute that this victim did suffer these abrasions. And so I would argue that on the facts of this case, this is not something that is truly inherent to any kidnapping. The cases that I'm familiar with that talk about that seem to be situations where maybe somebody has grabbed somebody by the arm, and in the process, maybe there's a red mark around their wrist or something like that. This was not simply holding a person. This was dragging them through the pavement on the driveway into the garage. And I certainly don't think it's fair to say that that act is inherent in any forcible kidnapping, a physical dragging of somebody over concrete that results in scraping to their back and their side. And furthermore, the panel, I think in this case, failed at all to account for the second incident that occurred near the street, which was observed by the off-duty police officer, where the defendant was punching the victim and kicking at her after she was already on the ground. And she talked about, I think in that incident, some of the pain that caused her. And so our position would be that even given the confusing state of the current law, that this is not a case where it was necessary to define that term.
Are you familiar with that case where the kidnapping case where after the initial taking, the victim was thrown into the river or water?
I'm not sure I'm familiar with that one.
But it seems to me that's where this notion of you don't have to have an actual injury to qualify for this bodily harm element. And the rationale, I think, would be that throwing the victim in the river was after the initial holding. And I wondered whether this second incident at the street wouldn't qualify with that. But if you're not familiar with the case, I don't want to push you where you don't want to go, but.
I'm not
that's
familiar
my
with the
question.
case, but the concept certainly, and I think I argued that in the brief, is that the cases do say that any essentially contact that occurs after the initial taking or confining qualifies for the bodily harm. And I certainly did argue in the brief that that incident that occurred by the street was after he had dragged her in the garage, kept her there for a number of minutes. Then when she finally does get free from the garage and she goes to her car and he refuses to let her leave, and then he runs after her down the sidewalk. And so at that point, it's clear that he had already confined her. He had already taken and confined her in the garage. That incident was essentially the taking and confining, and by that point had already been effectuated. And so, yes, I think when he's then striking her and kicking her while she's on the ground next to the street, I think that even if this court were to say that the scrapes that she suffered from being dragged into the garage are incidental to the forcible taking, what happened by the street wasn't. He, at that point, I don't know that he was even physically trying to take her anywhere. I think he was just trying to hit her and kick her. And so, yes, I think that because that occurred after the taking had already occurred, that would also satisfy and be a reason why the instruction was not necessary in this case.
But I don't understand that, because if that's true, you know, I mean, is there some kind of temporal issue there? Because why wouldn't that just be a separate, you know, aggravated battery or battery charge?
Right. And I appreciate that question. And I think that the panel, on that particular topic, I think the panel did a good job of addressing that, where they essentially said, this was all still, it's not a situation where you'd have multiple acts or any intervening impulses. It is still all part of the same overall act. Time-wise, I think, again, the testimony was that she eventually gets out of the garage. She goes to her car hoping to leave, but he immediately follows her before she can even start to drive away. She then gets right back out of the car and starts running through the bushes, and he very quickly catches up to her, and that's when he inflicts the blows to her as she's on the ground. And so I think it is a fine line there, that our position is, no, it's not a separate incident. It is all part of the same overall act. It wouldn't be a multiple act. But at the same time, because he had already taken her into the garage at that point, and essentially, you know, the taking and confining element had already been accomplished, that the later injuries that he inflicted as he's punching and kicking her on the ground under that case law, those are sufficient. And it doesn't matter whether you could say they were trivial. But
Let me just ask you, I'm going to circle all the way back around to Justice Ball's first question. You know, we can say all this in case law, which we have done for the last 30 or 40 years. But it's just not reflected in the statute.
correct.
And so, you know, the jury instructions are based on the statute, like they should be, because that's how it works. So I'm not seeing, you know, I mean, we're stuck with this. So there's a big disconnect here that I just can't connect. I'm not getting it. You know, I don't know how we resolve this, because you've got in the statute, bodily harm has been done, and that's all the jury is given. And so what are they supposed to do with that?
I think the simplest way for this court to handle it would be to simply recognize that the case law has been inconsistent with the statute, that the statute doesn't say that trivial injuries are not sufficient if they were part of, the inherent nature of a forcible taking.
Yeah,
And-
but that's the whole point, right? Because we have to differentiate between a kidnapping versus an aggravated kidnapping. And by statute, that's the bodily injury. But that means that because kidnapping, not the aggravated version, can be accomplished by a forcible taking, any sort of injuries that are just incidental to that type of forcible taking have to be differentiated, right? Otherwise, there's no distinction between the aggravated version of the statute and simple kidnapping.
Well, I think that
When,
distinction.
when it's a forcible taking.
I think that distinction can be made without the trivial injuries don't count rationale. You could say, and if this court were so inclined, you could say, no, even from this point going forward, if you simply grab a person by the arm and as a result, you do cause them physical pain, and or, a red mark on their arm, even if that's trivial, that's enough because it is bodily harm, as opposed to saying that
But then
it has.
every forcible taking would be an aggravated kidnapping, right?
No, I think anytime you could very easily at gunpoint force somebody, in this case, let's say the.
By fear, but if
Right,
it's by
exactly, but
force.
you could put your hand on somebody's back and lead them into the garage in this case. You are forcibly, you're putting your hand on their body in that type of situation, but there would be not only no visible injury, but no pain inflicted. It would simply be leading somebody forcibly. And that would still, in that situation, I think that could be considered a simple kidnapping because there's absolutely no bodily harm of any kind, trivial or not. Whereas when there is injury inflicted, whether it's a tiny scrape or it's you grab somebody and in the process you cause them and the victim says, yeah, that hurt my arm in the process, that would differentiate. And so I think you could draw that line without needing to basically go beyond the statute with this exception for trivial injuries not counting. And I think you're right, Justice Standridge, that the statute is what defines crimes. And to the extent that the case law is not consistent with that, I think this court, that's one way to resolve that is to say that those prior decisions have simply gone too far and imposed a restriction that is not included in the statute that
Yeah.
defines the crime.
Interestingly enough, when I'm looking at this, when I'm comparing the statute to the instruction given, aggravated kidnapping is taking or confining accomplished by force, threat, or deception when bodily harm is inflicted. And then, but the instruction only says, oh, it does say by force. And it seems like that's what we're talking here is the by force, not necessarily. So that's the distinction that I think Justice Wall is making is, by force, if it was just by force, then that's just plain kidnapping. And then when bodily harm is inflicted, that makes it aggravated, right?
Right. And again, I don't dispute that. And like I said, I think you can easily come up, as I just did with the scenario where you do physically touch somebody in the process of taking them, but you don't inflict any harm whatsoever. And in that scenario, I would agree that that would seem to be a simple kidnapping rather than an aggravated kidnapping. But when there is any type of, whether it's visible injury or just physical pain that the victim can identify, that would take it into the aggravated context, regardless of whether you could say, well, it was just incidental because it only happened when the kidnapper grabbed her by the elbow and caused her pain. And so I think that is a distinction that this court could make. And I think it would have two benefits. One, most importantly, it would be consistent with the statute. Secondly, it would certainly lead to a lot more clarity, and as opposed to having to try and find the thin line between, well, is this injury trivial or is it not? you know, again, our position in this case is that these are not the type of injuries that are incidental to any forcible taking. This was not something where he just grabbed her and caused her some temporary discomfort. He dragged her through the ground, through the driveway, enough that not only did it cause the scratches to her, but it tore her clothing or her coat. I think her shoes were also torn in the
Is
process.
pain bodily harm?
I would argue that it is. I think that, and a common person hearing that term would probably, you know, I don't think that's another reason why the term doesn't need to be defined, is it's a fairly common term. This isn't a technical legal definition that a lay person would need guidance on. I think that
So if you twist my arm and I feel pain, that's bodily harm.
I would certainly argue. So you know, personally, I would rather, you know, as a person thinking about what would I rather have happen to me? Would I rather have an abrasion, or would I rather have an internal injury to my body that causes me significant
I'm
pain?
not talking about an internal injury. I'm just saying pain.
Well, I would argue that pain, I mean, if somebody grabs your arm and it causes you pain, then there's something going on that is causing that pain, whether it's a muscle or a tendon, whatever it is, something is happening inside your body there to cause that pain. And I think that certainly qualifies as bodily harm. And I think a lot of times that would be more serious to a victim than a scratch that's going to heal relatively quickly. But I think that either of those two things and many other things would also meet the definition of bodily harm.
Is it bodily harm or bodily injury? And is there a difference?
I think the statute is bodily harm. So I don't know that there's,
The statute uses both words, with the intent to hold such person to inflict bodily injury or terrorize when bodily harm is inflicted.
so yeah, so looking at whether bodily harm was actually inflicted. I don't know, I suppose there could be a doctor who might be able to to tell us if there's any difference between bodily harm and bodily injury. I again would argue that in this case, under either word, what we have is sufficient here. She did suffer both physical injuries, which would suffice as also harm. But our position would be that even if there isn't a physical or a visible injury, that would still meet the harm portion of that definition. So I know I'm well past my time, and I'll obviously answer any other questions that you have, but our position is that to address the questions this court asked, yes, it is appropriate to consider it. Second of all, our position is that it should not be included in a cumulative error analysis because it would be contrary to the language of the statute, and it would give the defendant a more favorable standard of review than he is entitled to when he failed to object to an instruction below. And then turning to the merits, our position is that, again, this court can clarify the case law by simply saying that the trivial injuries aspect of it is not consistent with the statute. And as an ultimate fallback position, our argument is that even if you continue to go with that case law, that the injuries in this case clearly were not incidental to any forcible taking, and that therefore the bodily harm instruction or definition was not necessary. And if there are no further questions, I would reserve the rest of my time for rebuttal.
Questions? Thank you.
Thank you.
Sharon?
May it please the court, Riley Moore appears through counsel, Casper Shire, Kansas Appellate Defender. Court of Appeals correctly reversed Riley Moore's aggravated kidnapping conviction based on cumulative error. First, Riley's jury was not instructed on an essential contested element of aggravated kidnapping, that being the intent to hold. Beyond that, this is a case where the state relied on minor, ephemeral scratches to achieve a level 1 conviction, a conviction as serious as forceful rape or intentional murder. And Riley's jury did not know that trivial injuries likely to result from any forceful kidnapping cannot satisfy that conviction. Taken together, these errors denied Riley the fair trial that due process considerations demand.
How do those errors get into the cumulative error pot, though? It seems, I really struggled with the panel's analysis, not only because it doesn't take into consideration the statute that requires unpreserved jury instruction problems to be clear error in order to be claimed as error. But the other thing that it did, which I thought was weird, was when it did cumulate them, it cited to State versus Taylor, which is one of my cases. And Taylor doesn't have any jury instructions in the cumulative error. It's 4 of the 6 were prosecutorial errors, which are constitutional in nature. So it didn't make any sense to cite that case for what they were trying to do, both in terms of the statute, and the case law. So let's get to the statute. How does an unpreserved jury instruction issue make it into the cumulative error pot unless it's clear error?
Sure. First, I would, and I'm not going to dive into this because it doesn't answer your question, but first I'll say it was clear error to begin with. And that was one of the things we
That's
preserved
been
in our
found to be
prosecution.
clear error, so
Right. No, I,
put it there, we would have to do that analysis, right?
yes.
The
but-
Court of Appeals didn't. There's
The
no
Court of
dispute about
Appeals-
that.
That's right.
Okay.
That's right, Your Honor. No, I agree. It goes into the clear error pot, because all the statute does, is set a standard, a reversibility standard when you don't object to an instructional error. It is not like, for example, 6404, which says if you have an evidentiary error, that can't be the basis for reversal. That's not what 3413 says. 3413 says you can't claim an instructional error unless it's objected to or it's clearly erroneous.
I don't see the difference. If it's got to be clear error in order to be claimed as error, how do you claim it as error in a cumulative error analysis?
It has to be,
It's not a mistake. I mean, it just basically is not a mistake that can be counted cumulative error if it's not clear error.
it's still an error though, and that's the way this court has done the analysis going back for a very, very long time, decades. We look to see whether the instruction is correct, whether or not it's error. And if it is, we look at that unpreserved instruction and we apply the standard of review that the statute says to apply. It has not stopped this court from considering whether or not there is error. It has not stopped this court from considering, from putting any error into the cumulative error analysis. And, it's our position that this court has been applying the statute the right way.
But regardless of how we've done it, I mean, no one's done it intelligently. No one has analyzed that statute to say it doesn't count once you get to cumulative error.
Right.
That's what the Court of Appeals did. I mean, kind of basically, it said, we don't have to consider clear error because we're going to throw it into cumulative error pot. And that seems contrary to the statute.
I disagree, Your Honor, because first of all, cumulative error is a different thing from instructional error. It has roots in United States Supreme Court case law. When you have errors in a case that are stacking up, you need to look at whether or not the cumulative effect of those errors denied a fair trial.
And the counter to that is the unpreserved evidentiary error. Because we don't put those in a cumulative error pot,
No,
even though they may have been mistakes,
yes, that's right.
they just go away.
And I think what this court has been saying in its recent opinions is that that's because 6404 is functionally jurisdictional, or at least quasi-jurisdictional in nature.
Well, isn't another difference, though, that we don't consider whether or not the evidentiary allegation is right or wrong? I mean, the objection, we don't even look at it to analyze whether it was correct or not correct. We simply don't know.
That's right.
But with this kind of an error, with an instructional error, we have actually gone through an analysis and we found something wrong with it.
That's right, Your
It's
Honor.
legally inappropriate or it's factually inappropriate. We went through that analysis as a court. So does the statute then magically transform that error that we found, but it's not clear error because it's not reversible? Is that mistake magically transformed into no mistake? It's correct.
No, no, it doesn't. All the statute does is say you can't reverse based on that instructional error unless it's clearly erroneous. It doesn't say that you can't throw it into the pot of cumulative error. And they're building on that, Your Honor. There are very good reasons to treat evidentiary errors differently from instructional errors. One, the language of the statute is different. 6404 says you cannot reverse based on an error. All 3413 says is you cannot find an instructional error unless it's clearly erroneous. But second, just as a practical matter, one of the reasons why we have the contemporaneous objection rule in the first place is because we need to give judges a chance, district court judges a chance in the first instance to conduct the trial fairly, and they don't get it if there's no objection. That is not the case with jury instructions. The court has an independent duty to make sure that it is instructing the jury correctly. And that is particularly true when we are talking about the essential elements of an offense. And when you leave out an essential element of an offense, which happened here, that is an error that is constitutional in nature. And that goes back to Nieder, US Supreme Court. So to answer your question, Your Honor, no, we can't just pretend, we can't use 3413 to pretend that the error never happened, because it did. And it needs to be thrown in the cumulative error pot.
Would you, no, go ahead.
The U.S. Supreme Court has a long body of case law that allows states to create their preservation rules and to set this forward. Are you saying that jury instructions are not in that they are just a animal of their own and they're set aside under Nieder?
I don't think I'm going that far, Your Honor, but I am certainly saying the legislature has treated evidentiary errors different from unobjected to instructional errors. They've used different language to talk about how we review them. Furthermore, the legislature has known for decades that this is exactly how this court treats unpreserved instructional errors. The legislature knows that they are getting thrown into the cumulative error bucket. You know, if the legislature felt like this court has been applying the statute wrong for decades, they've had every opportunity to change it, and they certainly haven't done that.
Would you at least agree that the way that as you just articulated, this court has applied this rule dramatically changes the standard of review for unpreserved instructional errors?
Yes, Your Honor, and justifiably so.
Well, but it may be justifiable as a matter of policy, but how is it justifiable under the language of the statute?
Well, because the language of the statute only talks about instructional errors, and cumulative error is a separate body
Sure,
of
but
law.
let's just say, as is often the case actually, that we have an instructional error which does not rise to the level of clear error, which is paired up with what I think probably we could get most, if not all of the bar to concede is a trivial error. I mean, something that is just, it's error, but it's so trivial that it doesn't even have a scintilla of an effect on the fairness of the trial. And we could all think of those kinds of errors. Now, all of a sudden you put those two together, you're really not considering the impact of the trivial error. What you are doing is dramatically changing the standard of review that you apply to the instructional error. Wouldn't that be the case?
Well, Your Honor, I would say that's the consequence of errors stacking up at trial. And that's exactly what cumulative error is.
So you're just saying that in effect, in those circumstances, the statutory command to apply clear error must give way in the face of a cumulative analysis.
Yes, I think that's a feature, not a bug.
Would you, you briefly touched on it. You you're arguing in spite of all this, this is not clearly erroneous, this error.
I'm arguing that it is
I mean,
clearly
it is
erroneous,
clear,
Your
I'm
Honor.
sorry, that it is clearly erroneous. Would you highlight your argument on that?
Certainly. First, I'll start with the bodily harm instruction, which, first of all, I'd like to point out, I heard some argument about whether or not the cases which set the definition of bodily harm that we use in the aggravating kidnapping context are still good law. I think today this is the first time the court is hearing those arguments. Those were not in the brief. Those were not in the petition. The Court of Appeals found error that wasn't petitioned. I don't think any of that is before this court, first. Second,
Wait, well, I don't think I understand what you mean. So you're saying that they raised it sua sponte? The Court of Appeals raised it sua sponte?
no, Your Honor, I'm talking about the argument that cases like Royal and Peltier, which lay out
Right.
the standard that we use in determining whether or not, in defining bodily
Right.
harm in the aggravating kidnapping context. I'm saying the argument that I'm hearing today that those cases are wrong and need to be, essentially what I'm hearing is that those don't reflect the law. None of that has been presented to this court before today.
Okay.
That's what I'm saying.
Okay.
The second thing I would point to as far as bodily harm is the state's closing argument, where they expressly doubled down on these scratches being the bodily harm to support an aggravated kidnapping. And we are asking this court to hold the state to that theory.
That when we are essentially charged in doing an error review and reversibility review, to looking at the entirety of the record. And that certainly is what the jury could also have done. They had heard the evidence about the entire incident. No one told them you could only focus on this injury. So if they had found any other injury that struck them, that probably maybe hadn't even been discussed by the attorneys in the case, they still could have relied on that. So why should we now restrict the state? Seems like you're asking us to reframe our standard for reversibility.
No, Your Honor, I'm asking this court to hold the state to the theory that they elected at trial.
This isn't a typical election situation where we don't usually use election in terms of electing what evidence we rely on versus looking at the entirety of the record. I'm just not sure that concept applies here, I guess. What I'm trying to say.
Well, Your Honor, I think the election has to mean something because there were, I think, potentially multiple acts issues that could have, come up if the state hadn't elected. Now we're talking about potentially, and of course, none of this got raised on appeal because by making an election, the state avoids that problem. It's a litigation choice to make that election. And I think the state needs to be held on it.
Except that the Court of Appeals citing Kesselring decided this was not, there weren't separate impulses, that there weren't different acts. So does that really apply either?
No,
I'm not sure that issue is before us, was challenged.
no, it isn't, Your Honor. And because there was no multiple acts issue raised, and the reason there was no multiple acts issue raised is because the state elected. So there is no multiple acts argument to make at this point on appeal. So they've shut down a potential appellate argument by making an election at trial. They need to be bound to that election, when defending this case on appeal. Furthermore, I see I'm out of time. I have a second part to the second answer to the question. As a practical matter, Your Honor, I'm fairly confident that if the state had bodily harm beyond the minor scratches that we put into our briefing and that they expressly relied on their closing argument, they would have pointed it out. This is what they have. And I am confident, and I believe this court should be confident too, that had the jury been told trivial injuries likely to result from any forceful kidnapping are not enough to make that an aggravated kidnapping, this court should be firmly convinced that Kansas jurors would have found this to be a simple kidnapping. And if the state needs to work as hard, the hypothetical that the state came up with to argue that, yes, there are simple kidnappings out there that would not be aggravated kidnappings. Well, if we have to work that hard to come up with the hypothetical, it's not very many. This is a level 1 offense. There needs to be a meaningful difference.
Why? Why does there have to be a meaningful difference? Why can't this statute just be the legislature telling, effectively telling potential kidnappers, hey, if you're going to use force to effect a kidnapping, you are at a substantially higher risk of being found guilty of the aggravated crime. Why isn't that what this statute is saying?
Because there is essentially, and again, this goes back to Royal, right? This is established case law that the state has not challenged up until today. So I don't think any of this is before the court because the Court of Appeals found error and it wasn't cross-petitioned. But it functionally turns virtually every simple kidnapping into aggravated kidnapping unless, I don't know, I suppose if the kidnapper asks politely, maybe it's not. But there has to be a difference because otherwise we wouldn't set out a simple kidnapping and an aggravated kidnapping. There has to be something that makes the aggravated kidnapping different.
Mr. Shire, hasn't the legislature made clear that kidnapping is the taking or confining accomplished by force, and that is simple kidnapping? And it is only when you have bodily harm that it turns into aggravated. So the forcible part of it by force is just simple kidnapping, correct?
Yes.
Okay, and it's only the bodily harm being inflicted that turns it into a severity level 1, right?
Yes.
Thank
What is your position as to whether or not pain is bodily injury, bodily harm, or both?
It's neither, Your Honor. Royal sets out what bodily harm is, and it excludes trivial injuries from that. So
Well, Royal also says that it's any touching against the victim's will.
right, and the critical part of the instruction that the jury didn't get isn't so much what bodily harm is, but what it isn't. Again, any forceful kidnapping is likely to involve some pain. I don't know how you forcefully kidnap somebody without, leaving some bruising, some mark, causing some pain. There's functionally no difference, again, between simple and aggravated kidnapping if any old pain is enough to elevate a simple kidnapping to an aggravated.
Like to say in wrapping up.
Your Honor, I would just close by pointing out that the bottom line here is that Riley was effectively denied a jury trial on 2 essential elements of aggravated kidnapping here. Not just the intent to hold, which was contested at trial, and which the complaining witness, indicate, if you look at volume 9, pages, I would say 107 to 110 or so, there was evidence at trial that she did not feel like she was held in the garage from the complaining witness's mouth. And he was also denied functionally denied a jury trial on the element of bodily harm by not getting the definition of bodily harm.
Do very much with the witnesses or the victim's testimony at trial, can we? Because we've got the additional evidence from the officers at the scene. I mean, she changed her story after the defendant's mother called her and after she talked to him, this boyfriend, girlfriend thing. So the jury gets to weigh which of the evidence they consider credible. And if we just focused on the evidence that comes in at the scene from the responding officers, it tips the balance the other way, doesn't it?
Well, that's a jury question. And when the jury isn't instructed on two essential elements of the crime, they're not weighing. They're not doing the weighing on things they aren't instructed to weigh. And that's the fundamental problem here. That's why Riley didn't get a fair trial, why this court should affirm the cumulative error analysis of the Court of Appeals, reverse the aggravated kidnapping, and make sure that Riley does get a fair trial on this.
Just one last question. And when we've dealt with clear error in the context of an omitted element, has our reversibility test been a little bit different, articulated differently, rather than firmly convinced?
That's a very good question, Your Honor, that I'll try to answer it as best I can, but to be perfectly honest with the court, I'm a little bit confused by the state of the law on that as well. Because obviously we have Nieder, which is the U.S. Supreme Court case. And then we have Richardson, which is this court's case that fully embraces Nieder, even in a case where the omitted instruction was not objected to. After that, we have Harmon, which doesn't address Richardson, but does say that there's a relaxed standard when the objection isn't
Well, it
made.
plainly applies clear error.
It
A jury instruction that deleted an element.
Yeah, I don't disagree with you, Your Honor, but it doesn't account for Richardson, which still embraces Nieder. So I think there's a lot of tension there as to, at minimum, it has to be clear error, obviously. And we don't think that the state can, we think this demonstrates clear error. But I think this court still has to account for Richardson and Nieder and how they affect the analysis, because it is an error. Leaving out an element is a constitutional problem. Thank you.
Thank you.
Thank you. May it please the court. I want to pick up by emphasizing how strongly I disagree with one point that counsel made, which is that the state had to work very hard to come up with some sort of a hypothetical that would satisfy something being a simple kidnapping, but not a aggravated. I didn't have to think long and hard at all about that. And I'll give you another example. Let's say that a strong 250-pound defendant simply picks up and carries his 120-pound significant other into the garage. Absolutely no visible injuries, no discomfort. It's simply picking somebody up because you're stronger than them and carrying them to a destination. In that scenario, there would be absolutely nothing to meet the bodily harm element. So even though it's forcible, that would be a simple kidnapping.
What if he grabs her hand and he takes her and she trips over her own feet and skins her knee?
I would argue that that would be an injury caused by his forcible taking. She wouldn't have been being led to the garage, but for his actions. But again, I think more to the point is counsel is suggesting that there's almost no realistic universe in which there would ever be a distinction between simple kidnapping and aggravated. And I think that's simply not true.
Well, opposing counsel also suggested that this issue is not properly before the court. Can you respond to that?
Yeah, I would just respond by noting that I was simply responding to direct questions posed by the court today. So
Does that mean
obviously
you concede that the state didn't raise it?
I do not recall, I don't think that I did in the brief specifically say that the Royal line of cases needed to be revisited. And yeah, so I mean, obviously it's up to this court to decide whether you want to go that route or not. But as for today's argument, I was simply responding. I didn't bring this up sua sponte today.
I mean, here's the way I was thinking about this the other day when I was pondering your case was we don't have to overrule the case law that excludes trivial injury in order to affirm this conviction.
Correct.
Under your view of the facts.
Absolutely. Yes. And then just picking up on a couple of other questions that this court asked.
I'm sorry to interrupt, but can I, but I will, because I want to get clarification.
Absolutely.
You just answered Justice Biles saying we don't have to overrule that line of cases to rule in the state's favor. But I want to narrow the question. If we look only at the scratches, not the second incident, would your answer stay the same?
It would, yes, because again, I don't think that these are, even if you want to say they're trivial, there's two parts to that test. It has to be trivial and they have to be the type that are likely to result from any forcible kidnapping. And again, I don't think that dragging somebody over a concrete driveway is incidental to any type of a forcible taking.
He dragged her by the hair, didn't he?
Yes, and she, like I said, not only did she suffer these scratches, but she, the coat was torn, her shoes were torn. So this clearly is beyond, to get to your point, if he had simply grabbed her arm and maybe his fingernail scratches her, maybe in that situation, you could say, all right, that potentially is incidental to any kidnapping. And so we would need to define the bodily harm element for the jury.
Let me ask you a question, and you may not know this answer off the top of your head. What severity level is just plain kidnapping?
I don't know off the top of my head. Counsel probably would be able.
You know that, I mean, do you know the difference between like the grid, the months?
I'm sure it is significant, and I think not to sound cavalier, I'm not concerned by that. I think, as Justice Stegall pointed out, if you're going to forcibly kidnap somebody.
Well, forcibly kidnap is simple kidnapping.
Right, but you should be alert that if in the process of doing that, you cause the victim any injuries that are not incidental to any forcible taking, that you are potentially facing a much more severe penalty
So
for that.
if a knee gets scraped, then you serve 12 more years.
If that's what happens, yes, I don't have a problem with that. Just like the law always tells us, you take your victims as you find them. Well, in this situation, if you do something and set a chain of events in place, I don't think it's unrealistic or unlikely to think that if you are leading somebody somewhere against their will forcibly, that person is likely to be panicked. It's not unforeseeable that person then could stumble, even if it's over her own feet as she's being guided to somewhere against her will. I did want to pick up Justice Lukert. You pointed out that the United States Supreme Court does let states set their own preservation rules. And I think it's important also to note here, nobody is saying that the defendant doesn't get review of his instructional issues. He gets review for clear error. He gets each individual issue to be looked at by an appellate court, even if he did not object below. I don't think that it's too onerous or too unfair to say that if you didn't object below, there is a distinction there and that you then can't lump them in as part of, if you can't show that any individual instructional error was clear error, you shouldn't then be able to fold it in to cumulative for the reason that Justice Stegall pointed out. You could very easily have a situation where, as Your Honor said, you have one other minor error in a case, a non-instructional error that everybody would agree was harmless beyond any shadow of a doubt. But if this court continues to say that, well, we can now look at the totality of the circumstances and whether he was denied a fair trial, that significantly changes the standard and it gives the defendant a more favorable review. Again, Nobody is saying that he's not entitled to review. And I know I'm past my time, so I'll just conclude by this. Counsel said a couple of times that this was a case where there were two essential elements that were not instructed upon. I disagree. We concede that the intent to hold element was missing. The bodily harm element was instructed upon. They didn't define bodily harm, but the jury was told that bodily harm was an element that the state had to prove in this case. And as this court knows, not every common word or phrase has to be defined for a jury. So the bodily harm element was there. So there were not two missing elements in this case. It was just the one, which was the intent to hold. I thank you for allowing me to go past my time on both portions of my arguments. For all of the reasons advanced today, the state respectfully requests that the defendant's aggravated kidnapping conviction be affirmed and that the Court of Appeals be reversed. Thank you.
Thank you to both counsel for your arguments. The court will take this case under advisement.